Are we live, Ms. Kreider? Okay. All right. And are we expecting anyone else for this hearing?
Your Honor, I thought Brett Gardner in our, it looks like he may have just joined.
You just joined.
Yes, he's with me.
Okay, sorry about that. All right, let's go and get started. Mr. Ayers, why don't you announce the name of the case and the cause number?
You bet. Thank you, Your Honor. Chris Ayers, we're on behalf of CBSPE1 LLC. Chris Ayers, Jack Ayers on behalf of the plaintiff.
And Your Honor, Wade Crosno and Brett Gardner on behalf of defendant AmTrust Insurance Company of Kansas.
And Your Honor, do you want me to put the cause number on the record too?
Please.
Sure. It's DC 20-09673. And Your Honor, plaintiff consents to conducting this in accordance with the court's procedures of Zoom hearing and alternative under the Supreme Court guidance and orders.
Oh, can you let him in? Sorry. Okay. I'm sorry. Yes, that's fine. Great. And we'll go ahead. Let me put you on mute 1 second. Someone just showed up here and I need to chat with them. I apologize.
No, sir. No, not a problem.
Okay, let's go ahead and get started. I apologize for the delay.
No problem. Shall I proceed, Your Honor?
You may.
So we are moving to set aside the default judgment signed by the court on December 3rd and to grant a new trial. And just as a threshold matter, I need to address the issue about whether the judgment is final or not. And I don't want to get bogged down on that in the limited time we have, because I think that point is ultimately moot if the court grants our motion. But the reason we bring it up is because if it is final, then we could be in a situation where our motion and the court doesn't rule on our motion by Sunday, then it gets overruled by operation of law, arguably, and we're in a position where we need to maybe take up
The plenary power would end this Sunday. Is that what you said?
Yes.
Like
If
2 days from now?
Yes, if it's a final judgment. Well, no, let me correct that, because what would happen is if this is a final judgment, which we say it's not, our motion for new trial would be overruled by operation of law on Sunday.
Oh, and then I'd have another 30 days.
You'd
right?
have another 30 days.
Okay.
But I guess what I'm saying is we would really prefer, if possible, to get
So let me kind of tell you, I've read both sides. I think that it was very well briefed. It raised some, I think, some very interesting issues. Craddock obviously is not a terribly high standard for new trials, but it does concern me that how this exactly happened was this conscious indifference. And am I understanding that they just ignored this tornado claim, or kind of what is the history of the claim?
Well, we don't believe they did ignore the tornado claim. There are complaints by the plaintiff about delays in responding and about not articulating the reasons for the decisions that were made. But we did, as outlined in our motion, we did make several payments of over $100,000 total on this claim. There are several letters that are even attached to the plaintiff's response where we forwarded payments, explained the payments, and attached supporting estimates and documentation for it. And I think that all, and I guess the second point I would make in response to that is that I think that confuses the issue between the handling of the claim and whether we were consciously indifferent to this lawsuit. And there's no evidence that anyone was aware of the lawsuit and just didn't care about it, which is the standard under Texas law. And we've attached several affidavits to our motion. I think 5 different affidavits from employees. And one of them is from the general counsel, Stephen Unger, and it sets forth the procedure that was put in place by AmTrust to try to prevent something like this from happening. Obviously, it didn't work in this case, but there was a system in place to try to prevent it from happening. And as we noted in our reply filed yesterday, the Texas Supreme Court said in the Fidelity versus Drury Construction Company case that the existence of such evidence is, or the existence of such a system is some evidence that that the defendant wasn't consciously indifferent. In addition to that, we've presented affidavits from the probably 3 key individuals involved who would have been involved in receiving this sort of notification, assigning it internally. And what they have said is that they missed it. And sometimes it's hard to say exactly why you missed something, but their affidavits, I think, cover the 3 most likely reasons, which are that they were getting a high volume of these notifications, that they were all working remotely during the COVID-19 pandemic, as many of us have been this entire time. And in the case of one of the key employees, that she was also grappling with the serious illness of a father at the same time and having to manage his healthcare situation because his English is limited. So those are the reasons. And based on the case law we've cited, like the Sutherland case, the Fidelity versus Drury Construction Company case, that explanation meets the standard of lack of conscious indifference. And it's not a high bar. It is that the defendant, to be consciously indifferent, the defendant had to be aware of the lawsuit and say, I don't care. And it's not a negligence or carelessness standard. And we also pointed out in our reply filed yesterday that we're all operating in this strange time where the Texas Supreme Court has issued a series of emergency orders. I just saw they issued another one this morning that extends in the order discussed in our reply, the court had said that trial courts may, and in certain cases must suspend deadlines through for a period ending no later than February 1st. That's now been extended to April 1st. And although COVID is obviously not a get out of jail free card, it is certainly a part of the explanation for what happened here, and something that the court can take into account and should take into account based on the Texas Supreme Court's guidance. And so for all of those reasons, we believe we've met the standard of showing conscious indifference. There aren't any controverting affidavits from the plaintiff here. About all they've said is you were aware that we were dissatisfied with this claim, which is not awareness of a lawsuit. And the only other thing they pointed to is a letter that Mr. Ayers wrote to our claims adjuster after the filing of the lawsuit, where he made a vague reference to litigation between the parties, and could have told her, we've sued you, your answer's overdue, what's the deal, but did not do that. And she said in her affidavit that she didn't understand that to be a reference to a lawsuit that had been filed or an answer being due in a specific lawsuit. And that evidence is uncontroverted. So for all those reasons, we think we've shown the lack of intent or conscious indifference, and that the first element of the Craddock test is satisfied. Now, the two other elements, well, the second one is that we have to set up a meritorious defense. And we presented the affidavit of Denise Dorsey, who was the claims adjuster, and that's Exhibit 3 to our motion. And she's explained that really two main issues, and one was a lack of documentation for about $190,000 of the business personal property loss on tenant betterments and improvements. And the other was just a dispute because there were 3 different restaurant locations owned by this plaintiff. One of them was damaged in the tornado. The other 2 were not. And they are claiming a business income loss in connection with all 3 locations, not just the one that was damaged. And we don't think that's allowed under the language of our policy. So we believe we've set up a meritorious defense. And then the last element is just that there be no injury or delay to the plaintiff. And what the case law says is that if you offer to reimburse them for their expenses in taking the default judgment, which we did prior to filing this motion, we said, hey, can we pay you for I think it was $11,000 in attorney's fees that were awarded in the court's judgment. And they didn't want to take that offer, and that's their prerogative, but we've made that offer, and that offer is open if the court will set aside the default judgment. And so we think we've met all 3 elements of the Craddock test, and we've also raised some additional issues in our motion where we would be asking for lesser relief, such as a new trial on the damages and attorney's fees, because those were unliquidated sums, and we don't believe the requisite hearing was held as far as we can tell. And we've raised a few other issues that I think our briefing adequately covers, but I want to give the court the opportunity to ask me any questions it has about any of this.
Not yet. Mr. Ayers?
Thank you, Your Honor. I'm going to start with the interlocutory nature first, and then proceed to the Craddock merits, if that's okay with the court.
Sure.
This is not an interlocutory judgment.
I agree with you. You don't need to go any farther. I think
okay.
it is a final judgment.
All right. And I also take exception, Your Honor, and I'm not going to let it go unsaid in a hearing, particularly where records being transcribed, with veiled assertions against either myself or the court. This court issued a 165A notice of intent to dismiss, which it's required to do. It's not an optional thing for the court. The Texas Supreme Court requires that under its judicial administration rules. And you did that. And then pursuant to standing order number 1 all the way through, you have had a procedure. I've appeared in front of this court, I don't know how many times since COVID, including 2 different defaults. And this court is very fair about how it conducts its default practices. And I'm going to show something in the default judgment, if I can share my screen in a second, that I think is important and instructive based off of how this court conducts itself. But here's the key. They want to gripe and complain to you about you having a standard of practice in your court that treats defendants who have not answered with fairness. So they want to harp at you and me for not going after the tort of bad faith and for not going after exemplary damages in a default setting, when my practice before this court has been one of this court overextending itself in protection to people who sat on their hands and didn't answer. And when you look at the screen, Your Honor, I want to show you something that I think is important. I can find the right one. Hold on one second for me. Can you see that, Your Honor?
Okay, yeah, I see that.
Okay. I had a default judgment in front of this court. I've had multiple, but you'll see this. I want to show this because it's important for purposes of the record. And it says the court finds and receives. It has received verified information, evidence, and testimony of the plaintiff concerning its claims and causes of action against the defendant, including the specific issues of contract formation, breach, violations of the insurance code, deceptive trade practices, proximate causing, and damages. Your practice during COVID and otherwise has been that you want the parties to bring forward as much evidence and proof that can be dealt with by this court without jeopardizing the safety of its staff and the lawyers and anybody else. And so we presented all that evidence to you in the form of an affidavit, and your judgment language has the absolute verity language required, which says before entry into the extent necessary, the court called its docket, the plaintiff appeared, announcing ready through counsel record, the court heard evidence and took judicial notice of the file. That is calling the case for trial. That is calling the court to its docket, holding the hearing, and doing the things that are necessary. And so the court is crystal clear. We didn't move on the tort of bad faith or exemplary damages for a reason, because this court is loath to enter exemplary damages or serial sets of treble damages or anything else without specific evidence of intentional or knowing findings. And so if you look at our judgment, I'm going to have to split this a little bit. You made a finding right here. This is the actual default judgment where you found and conclude that intentional and knowing violations had happened. But yet I know this court and I know how fair it is. And when we go to the actual language of the decree about what will be imposed, you will see I did not ask for those treble damages. Why did I not ask for those treble damages? Because this court believes that's not the appropriate practice before it to give treble damages when we don't have actual direct evidence of an intentional or knowing violation, nor malice, nor gross negligence. So really the first complaint is that I've been over backwards and the court bent over backwards to extend the courtesy to protect the defendants when they didn't show up for themselves. And that's outrageous. It's insulting and it's outrageous that would be said to me or to this court. Burlington, I'll dispense with that, but I'm not going to let that go unsaid. When you skip to the Craddock factors, this case is actually very simple, which is you, judge, are the fact finder. It doesn't matter what, as I said, Judge Nelson or Judge McCleveland or Judge Zapata or Judge Unger, who all self-appointed themselves, believe. It's what Judge Hoffman believes, because that's the only real judge here. There's only one judge, and it's not the defendants and their agents, it's you. You're the fact finder. Are they seriously asking you to contend that in the face of failing to adhere to strict statutory deadlines under the Texas Insurance Code, 4 months, that then this lawsuit was filed? And then after the lawsuit was filed, that their multi-system tiered redundancy-based electronic system and personnel system, it actually simultaneously, instantaneously, and coincidentally all failed. That's what they're asking you to believe. And here's a shock, you don't have to believe that. So when Mr. Unger, the general counsel, comes in and proffers an affidavit to you that says, in effect, I'm the general counsel, but I don't bother myself with litigation matters involving my company. I'm really focused on other things. I don't think you probably believe that. I believe that you think that as the general counsel of a national insurance company, Mr. Unger sees to it when his company is sued who pays his salary. And likewise, the blame game that exists between Miss McCleveland and Miss Nelson over onto Miss Zapata, when all three of them and Mr. Unger Any of the four of them could have handled this lawsuit. And the fact is, they all chose to do nothing. And then when they file their affidavits and you say, well, why did you do nothing? They give you these vague conclusory statements. I don't recall seeing the lawsuit. I don't recall it being in there. There is absolutely no specificity from them whatsoever. And we lodged objections to that. In the objections, there was no response whatsoever to our objections. And then they say, well, we were stressed. We were challenged. How? You don't get to just say you were stressed or challenged. You've got to say how that happened. How were you challenged? What stress did you have? What challenges arose? What implements to you getting your job done were there? There's no foundation for that at all. It says, I refer to vague notions of the law. That's not sufficient evidence.
Let me just ask this. So obviously, Craddock is not a terribly high standard. I am concerned just the way this has all progressed does this insurance company really seem to have some difficulties handling this claim, and then eventually, how exactly they didn't know to file an answer here, given the fact that you sent them a letter and everything. There's a couple ways that we could go forward here. One option, I could deny the motion for new trial. They'll take me up on appeal. The new Court of Appeals, I don't know what they'll do with this. I think it's 50-50 that I get affirmed with this Court of Appeals. The other option would be I could take this under advisement and order you guys to mediation. What do y'all think?
So I'm gonna tell you, Judge, that practical solution is exactly what, when Mr. Crosno called me on the phone about this, I asked him. I said, let's get to the substance of this. This claim has been pending for a year. Talk to me about the substance. After, by the way, I asked him, was this a Craddock issue involving your office, to try to extend him the professional courtesy? I asked Mr. Crosno exactly what you just said, which is, let's get to the substance of this. And he said he couldn't speak to it. So they continue to not want to speak to the substance. I want the claim resolved. My clients want the claim resolved.
Mr. Crosno? You're muted, sir.
I apologize for that. What I said at the time is that I will reimburse you for your expenses in taking the default judgment, and we can move forward. That offer was declined, and I said, well, we're going to be focused on overturning this default judgment. And then my partner in Dallas will handle the merits of this claim. The issue, I never oppose mediation, and I'm not going to here. The problem I see with that is, if the court doesn't rule on the motion, in the meanwhile, I think
so let me tell you my thoughts on this. Is maybe I order you to mediation. I have some ideas on who I would send it to. I guess Mr. Gardner is kind of your local counsel, so he probably knows the mediators a little better. But I have some that we can usually get to pretty quickly, and then reconvene this hearing in like 2 weeks so that we can have a final decision on it.
I can certainly recommend to my client that they do that, and I'll need to check with them on that. My concern is the overruling by operation of law, because I think the court said that, I think you said earlier, but I want to make sure I heard this correctly, that you view the default judgment as final rather than interlocutory.
I view it as final, yeah. I mean, whether the Court of Appeals will agree with me, I don't know. But if that's the case, then I have 30 days. So if we reset this hearing for 2 weeks, and I can make a final decision on it and let you guys finish your arguments and send you to mediation in the interim, is kind of my thoughts.
Well, I don't want you to get boxed into a Burlington situation, because this is exactly kind of what happened in Burlington, where the judge was trying to do the right thing, and then somebody spun it on him after the fact and then got him into trouble. One option would be, I've got, you can't see him, Judge, but my dad is in here. Can I have 2 seconds to ask him a question real fast?
Okay. Once this hearing is over, I'll go ahead and do the wedding.
I don't know if he'll agree.
Judge, what about this? One issue that Mr. Crosnow raised in his motion was reformation of the judgment to make sure that there was no lack of clarity about the attorney's fees being in the event only if an appeal was successful. And I'm asking Mr. Crosnow, he may need to think about this for a second or talk to Mr. Gardner. What if I uploaded a new version of an amended final default judgment that changed the language and put successful in on the attorney's fees, to the 3 clauses on the attorney's fees that would get us out of the jam that we're in? If you could sign that today, that would kickstart new deadlines. Does that make sense? And then you could order us to mediation.
So do an amended default judgment.
Correct. That would, once you sign that, having
Well,
modified
if we
it.
amend the default judgment, I think you also need to make it clear that any claims that I didn't rule on before the default, the request was denied, because I don't think that could also make it clear.
Correct.
too.
I'll believe me, I'll make sure any of these issues about the interlocutory stuff are going to get fixed. So I'll fix the.
So what is the Burlington issue with ordering them to mediation, ordering you guys to mediation?
What happened in Burlington was the trial judge heard a motion for new trial on craddock grounds and granted it and said, hey, I think there are grounds for a new trial. And then after that, all that hearing happened, the plaintiff came back and said, no, you didn't have jurisdiction to do that. And then the judge said, okay, well, I guess I didn't have jurisdiction. And then you're going up on an appeal in which the judge said, you know, these people should get a new trial. And yet the plaintiff had made the argument they didn't have jurisdiction. And so it goes up in this adversarial context of basically the judge having to go against what he thought was fair, just, and right. And so that's what led to the Burlington ruling in our view. And so I don't want Mr. Crosnow to be prejudiced by, you know, hard and fast jurisdictional deadlines relating to plenary power. And I'm trying to.
That has nothing to do with the ordering them to mediation. It's just the deadline.
I think Mr. Crosnow's position is if we don't get something done by Sunday, right, Mr. Crosnow, that then we have exhausted potentially some of the plenary power, but maybe not.
Well, it would be overruled by operation of law on Sunday, and then the court would have another 30 days. I think that the proposal.
Let me just say this. This is what I'm going to do. I'm going to amend the order. That should reset the deadlines. I'm going to order you guys to mediation, and I'm going to reset this hearing for, just in the abundance of caution, 3 weeks from today. So that will be, let me make sure I can do that date. 3 weeks from today would be February 5th. Why do I think I have a conflict on February 5th? No, February 5th works fine. We'll reset this hearing for 10 o'clock. Mr. Mediators, Mr. Gardner, your local counsel, right? So I could probably get you to Judge Ginsburg within the next 3 weeks, or is there somebody else that you want to try to use that we could get you to quickly?
Judge, yeah, I would probably, I mean, it'd be ideal to kind of think that over, but Judge Ginsburg is obviously, we respect Judge Ginsburg. I know it's going to be difficult, especially this time of year, to get in with a lot of folks that kind of time frame. So
let me text him right now and see if he's available. Does next week work for you guys?
Well, we will need to check with our client and make sure we can get someone there from our client.
Judge, I can't do next Thursday or Friday, but I'll otherwise move anything else. I'm committed to.
Why don't you get Mr. Crosnow? Why don't you get your client on the phone, and I'll get Mr. Ginsburg, Judge Ginsburg, on the phone.
Okay.
Please leave your message.
Okay. All right, I usually can get him on the phone pretty quickly, but he may be busy. So go ahead and reach out to Judge Ginsburg. I'm going to order the mediation to occur within the next 3 weeks. Rhonda, go ahead and reset this hearing for 3 weeks from today at 10 o'clock, and we'll get you a new order on that. And if there's any problems, just reach out to me with Judge Ginsburg. We'll get you a new mediator. Anything else, guys?
You want me to upload that new default judgment?
Yes. Upload the new default judgment since the timing is so critical. Get it to me as soon as possible. Email it to Rhonda and e-file it. And Rhonda, make sure you email that to me today because I need to get this order signed today.
I'll get it done, and I'll make the modifications to show it as an amended, default judgment. I'll clean up that those two claims were not part of the default judgment, and then I'll add the successful, if successful, language to the attorney's fees. Is that your order instruction?
That's it. Thank you, guys.
Thank you, Judge.
Needed.
Thank you, Your Honor.
Are you back in the office, Jessica?
I am, yes. Can you tell with the background?
How's the scene there in terms of restrictions and so forth?
I have about 25% of our office here at the moment, so very, very sparse.
Are the numbers bad there?
We were a level purple, which is the worst in the state, a few weeks ago, and we've dropped down one level, so not great.
Well, while we're waiting, hi, Lauren Jobin.
Hey, Leslie, how are you?
Good. I haven't seen you in a long time.
I know I'm still alive, shockingly, but I think I'm not in the office today, but we've got like I have depositions today with Fee Smith and they're insisting on doing them in person. So after this, I'm going to have to drive up north and go to the office. I didn't realize, I guess we have like a ton of hearings that everybody's doing at once, back to back.
I think there's two. We just have a large group for our hearing.
Yeah, I was like, because
Or at least looking at the docket, it looked like there were two things set at 11.
okay. Yeah, and my depo starts at 1.
don't charge. And I definitely wouldn't charge for you. Did you leave a little present or something?
I did on the side table. It was for Christmas, but you were in Durango and it had perishable stuff in it, so I put the perishable stuff in my refrigerator. There was a card on it. My kids tore it off. So.
Oh well, thank you. It wasn't necessary, but thank you so much.
I forgot we were in Durango. But anyway, Happy New Year as well.
Ms. Jobin, what are you here for? I didn't know you were on this case.
No, I am not, Judge. I'm here for the motion to strike.
Muted, or can you guys hear me?
I turned your sound off.
Oh, oops. Okay, my sound is off. What do I do here? Ms. Jobin, I couldn't hear you. Are you there?
Yes, Judge. No, I was letting you know I'm here for plaintiff's motion to strike controverting affidavits on Alicia Kaysen versus Ballister Barnes and Lance Broussard.
What time is that set?
It's set at 11 was my understanding, unless something weird has gone on. And
That's very possible. I'm running a little bit behind today. I apologize keeping you guys waiting. I had a wedding and then a million hearings this morning. Let's see.
Your audio is kind of weird, Judge. Does everybody else hear that, or is it just me? Yeah.
Can you hear me or no?
I can hear you, but it's like, sounds like you're speaking through one of those like voice boxes, so I can't tell. So people can't know who the person
Weird.
line is. Yeah.
Let's see my sound. My speakers are on. Let me go all the way to the top. Is that better?
No.
No, okay. Let me do this. I'll go ahead and sign off then, and I'll come back on. All right, can you guys hear me okay?
That's better. Yeah, now you sound more.
Okay. Is your opposing counsel here, Ms. Jobin?
Yes, Your Honor.
And where is she? Mr. Peer, okay. All right, we're hearing a motion to strike affidavits, is that correct?
Yes, Your Honor.
All right, let's go ahead and proceed.
Your Honor, we filed a motion to strike the counter affidavits that were filed. One is Dr. Duffy, who's an orthopedic surgeon, and then the other one is Robinson, who is a chiropractor. The issue with Dr. Duffy's counter affidavit is he's not saying that any of the treatment wasn't necessary. He's just attacking the charges. And I understand that based on, and you've seen, I've been in front of you on so many of these, but the way he's described, I understand that he's in private practice for however long, but the opinions that he gives are really just as a billing expert. And the way that he kind of couches whatever his opinion is of whatever reduced amount, he'll put this charge seems rather high, and then says, I'm basing this on reasonable transaction fees. He's not identifying to me where he's getting these I don't know what a transaction fee is. He's not actually saying this is not reasonable and customary for the DFW Metroplex for the relevant area where Ms. Kaysen got her treatment. He's basically just saying, I don't know if that means, where I've seen this a lot, where a transaction fee is that regarding whether it was submitted to health insurance. I don't think he's just given these conclusory statements that I don't think meet the requirements under 18.01 as being a valid counter affidavit, since he's really just opining as to bills. And I don't believe he's qualified as to opine to the billing of a surgical facility, because he's not saying, had his counter affidavit stated, when I do this procedure or when I do this injection or where I perform this surgery, I charge X, which is reasonable and customary, and this is not because of that reason. He's just giving these blanket statements. This is based on reasonable transaction fees. So I don't believe that that his opinions in his counter affidavit, I think they should be struck completely as to all of his opinions regarding the billing, which he goes towards the treatment that was provided by SOAR Institute, which did the pain management, and then also as to the costs of the radiologist. which also I don't think he's qualified as to opine as to the charges of a radiologist since he himself is a DO. And so that's the position that we're taking. I don't think he's qualified as a billing expert. I think he's qualified as an orthopedic surgeon, but the way that he's phrased this counter affidavit, I don't think is right. And I don't think it meets the rules. And then as to the chiropractor, his opinions are, he is going as to the reasonableness of the treatment, which we're not really making a huge argument about because we'll be bringing that doctor live regardless. But as to his opinions on the billing as well, he is also giving these ranges, which is also what Dr. Duffy does, which is problematic to me because it's maybe it's 500 to 700. Well, there's a decent disparity between that, right? He's not giving a specific amount. And I also don't know where he's getting this information from either. It just says detailed exam $295. He thinks it should be $100 to $175. And he says, this is because they were a little excessive. So it's a similar kind of explanation that I don't think meets the requirements. So I would argue that his opinions as to the billing should be struck. We're not making the contention that he can't testify as to the reasonableness of the treatment because we will be bringing the chiropractor live as to that. And Dr. Duffy, the orthopedic surgeon, he says that all the treatment is necessary. He really is just limiting his entire opinion as to opining as to the charges. And it's our position that he's not qualified to do that. And so his counter affidavit should be struck.
Okay. Response?
Good morning, Judge. Can you hear me?
You may.
Okay. Regarding Dr. Duffy, I'll say this. I think the reasonable inference from his experience in this area is that he does know the billing practices in this area. I think he would be qualified to at least give reasonable notice of his basis for disagreeing with the levels of charges from the different providers he talks about. I would say he is qualified to at least comment on that. And again, just give reasonable notice for why he disagrees with those levels. And of course, he does agree with the necessity for those past procedures. So we're not here to argue about that. I think Dr. Duffy, just based on his experience, would be qualified to comment on the charges. As far as Dr. Robinson, and of course, I was not aware that they were going to bring their expert to testify at trial, so it might resolve some of that. I think, again, we're not, I guess, going to argue over the necessity arguments. I think he does explain those in good detail. Again, same thing with Dr. Robinson. If he is swearing his affidavit, he has experience with the fee schedules in this area, and that in his opinion, this is why some of these fees are excessive in some parts, and some of them he agrees are appropriate. So he's not blanketly saying none of them are appropriate. He is at least conceding some of these are reasonable bills. I think that gives him some degree of credibility and credence that he's not just disagreeing with everything just to be disagreeable. He is carefully delineating which ones are reasonable, such as the detailed or some of the EMS. He's very close in some of those bills, but he does at least offer some insight over which of those bills are grossly exaggerated, such as the MRI bill. And I think, given that he does allow for some of the treatments, I think he has shown he's credible. He's shown that he has gone through the records carefully, looked at them with a critical eye. He's given allowances where they're to be given, and he has said these things are necessary, but they're overpriced. I think that at least gives, again, reasonable notice for why he's disagreeing. I know they're going to disagree with his assessment that some things are overpriced, but he at least gives, what's required by 1801, a reasonable notice that these items are a little bit pricier. And especially if we're talking about having their expert testify at trial anyway, I guess the real issue is if this will allow our expert, if we want to call him at trial, to testify. So I think it would not be appropriate in that case to strike his affidavit and make it where he cannot at least testify and offer his opinion on the subject. So I would submit to the court that it would not be appropriate to strike those affidavits from either Dr. Duffy, but especially Dr. Robinson. I think Robinson did a really good job explaining his basis for what was necessary, and also explaining a detailed breakdown of what was overpriced, how much was overpriced, giving concessions where need be. But I think that lent some credibility. And it provided what we're supposed to provide, which is reasonable notice for why we are controverting their charges. So I think for those reasons, I'd ask the court to not strike the affidavits.
I'm going to go ahead and strike Duffy's affidavit and not strike Robinson's affidavit. Do we have proposed orders for that?
I can submit, because I think the order that we had filed would be for both. So I can go ahead and have another order drafted, and then do you want me to shoot it over to you, Gary, so you can look at it and approve as to form, and we'll get it filed today?
And make sure you email it as to Rhonda as well as e-file it.
Okay, I will do. Thank you very much, Judge.
All right, guys. Thank you. Have a good day. Have a great weekend.
Thank you.
All right. The Hume case is back again. How are you guys doing today?
Morning, Your Honor. Good. How are you?
Your Honor.
Morning, everyone. So is this a continuation of the previous compel hearing? You guys thought you had everything worked out, but you weren't sure. And is that this hearing, or is this a new one? I don't recall.
That's it, Your Honor.
Yes, this is a
I thought it was a continuation. So I assumed you worked everything out and you're just reporting back. Is that correct?
I wish it was that simple. I will say we have reached agreements on a number of issues, significantly reducing them. There's only 4 issues, as I understand it, that we need your help with, Your Honor.
Okay.
Your Honor, we would request a record today, even though I normally wouldn't on a discovery. There's some issues that could continue through the case. And so if
Sure, that's fine. Tony, why don't you go on the record? Ms. Shigaris, why don't you announce the case name and the cause number?
Thank you, Your Honor. Cause number DC 2008643, Mark Holm and 5 Points Holdings LLC versus 5 Star Global LLC et al.
Ms. Pettit?
Your Honor, in regard to our motion to compel.
No, you need to announce your name and who you represent.
Oh, I'm sorry. Julie Pettit on behalf of the plaintiff, Your Honor. My apologies.
Ms. Reimer? Mr. Reimer?
Yes, hi, Your Honor. Ben Reamer here on behalf of Michael Null and Mid-Marketplace.
Ms. Lopez?
Hi, good morning, Your Honor. Jessica Lopez and Ms. Shigaris on behalf of the remaining defendants except for Southfield.
Ms. Krajewski?
Good morning. I'm Sarah Krajewski on behalf of.
Oh, sorry. I got that name completely wrong. Krajewski. Ms. Krajewski? Go ahead. Say who you're representing.
Yes, I represent defendant Southfield.
Okay, so you said there were 4 issues left, Ms. Shigaris, that you wanted to chat about?
Yes, Your Honor. I actually have a PowerPoint to share. I think will hopefully give some context to the issues. If I can share my screen here.
Sure.
All right. Can you see that, Your Honor?
I do.
So when we started this, and still to this day, plaintiffs have not produced a single document to the defendants. But like I said, Ms. Pettit and I have worked over the last couple of weeks and reached agreements on all but 4 issues. The first is for the production of native QuickBook files. And I'm going to walk through each one of these in detail. So I just want to highlight for you what the issues are. A relevant time period for financial documents, the production of Mr. Holmes' tax returns, those portions of which would relate to monies received from FSG entities, and then certain information pertaining to 5 Points use of FSG's employees and equipment. Otherwise, it's my understanding that we've reached agreements. In this case, we've talked a lot, Your Honor, about plaintiffs' claims against the defendants, but here, Your Honor, we have a number of counterclaims against the plaintiffs, which give the right background for why we need these certain documents and where the disputes are. So I'm going to not spend too much time, but I do want to give you a little bit of context for where the requests come in. As you already know, Your Honor, 5 Star Media, that's now called 5 Points, that's the plaintiff in this case. And they had a lot of different assets, business lines, different LLCs, and that was kind of a holding company. Our client, FSG, came in and purchased a substantial number of those assets and business lines, other than specifically excluded assets that were listed in the asset purchase agreement. Part of the asset purchase agreement specifically states that our clients purchase the books and records for these entities and business lines that we purchased, as well as all the email accounts. And that's going to be relevant when we get to the request in a moment. Again, I know Your Honor already knows this, but just the structure of kind of after the FSG transaction, what did it look like? So CCP Wolf, that's one of my clients. It, along with some other outside investors that aren't involved in the litigation in any way, own 50.1% of the FSG holding company, which owns FSG. That's the operating company. That's the entity that does the stuff. And 5 Points Holding, that's the plaintiffs. They retain 49.9% equity in this structure. But who is really running the companies? So we've had a lot of back and forth in this claim that Mr. Holm, after he sold the companies to my clients, that we've run the companies into the ground. But I want the court to understand really who was in charge of the companies. So after the transaction, CCP Wolf, who again, one of the defendants in this case, has a management services agreement to help provide those services to FSG. Mark Holm, who was the chief creative officer when it was 5 Star Media, that becomes 5 Points, he comes over and he's still the chief creative officer. And then El Delgado, he was the president and CEO when it was run by Mark Holm, and he came over and he continued to serve as the CEO and president of these companies. Not too long after the transaction, so the transaction closes in the middle of 2018. And in early 2019, Mr. Holm came to Mr. Delgado and said that he wanted to resign. He didn't want to work in the company anymore. But in order for that to happen, they had to actually negotiate, per the employment contract, a severance agreement. And there was some discussion of keeping him on in some kind of consulting role. Well, no agreements were ever reached. And so, sorry, I'm going to ignore that phone call there. No agreements were ever reached. But for whatever reason, Mr. Holm effectively just stopped working for the company. He didn't do anything from April 2019 until he was finally terminated for cause in January 2020. And that is even though he continued to collect his salary and all of his benefits from the company during that entire time. As I mentioned, we have a lot of claims, and I'm not going to go through all of them today, Your Honor. I'm going to talk really just about the top 2 or 3 on this list that are the most relevant to the discovery request at issue. Our clients have sued the plaintiffs for fraud as it relates to the asset purchase agreement and that transaction, because we believe, and I'm going to show you just a couple of emails, that the plaintiffs manipulated financial information to make it look like the assets that 5 Star were acquiring were worth a lot more than they really were. And from the limited discovery we've received so far, we've been able to see that, but we need certain other documents so that way we can prove that theory at trial. We also believe they've breached the APA. That is, Ms. Pettit's clients owe our clients hundreds of thousands of dollars under the APA, under this adjusted net working capital that they've still not paid our client. And then, of course, that Mr. Holm breached his employment agreement when he decided to basically abandon the company. Okay, the plaintiff's fraud. So this is really the kind of crux of the issues that are before you today. What we have already learned from the limited documents we've been able to get is that the assets that our clients purchased were already under significant financial distress, and they were experiencing cash flow shortages. So bad that they had to go out and get shark loans. That's the plaintiff's words, not mine, in order to just make payroll and cover expenses of the company. And they also had lawsuits pending against them that they didn't disclose. All of these things the plaintiffs have now admitted through their written discovery requests are things that they did not disclose to the defendants before we closed on the transaction. I've got a bunch of emails here. I'm not going to spend too long on it. I just want to show you a few, Your Honor. But you can see, so John Harris is the CFO of 5 Points. It's the plaintiff's company. and he's talking with Mark Holmes. This is in November of 2017, after they've signed an LOI with our client, but before the transaction is closed, talking about how they have to find cash and that pursuing these kind of shark loans might be the way that they need to do it. Mark Holmes responds, okay, well, our plan is we're going to take this shark loan out, we're going to cover payroll, and then we're going to bank the rest. Mr. Harrison responds to him, well, he's a little concerned if they show a profit, if they bank that shark loan, because he knows that they actually have a negative cash flow. If you look, again, same time frame, November 2017, we've already signed the LOI, we're doing due diligence, we haven't closed on the transaction yet. And Mr. Holmes is writing to yet another person that he owes money to, saying that he is in a horrible place, but they're going to close on this equity deal, and that's going to fix everything. And the equity deal he's talking about here is the deal with 5 Star to come in and save the day. There's many, many other emails where they're talking about the need for these shark loans because they've basically taken all the cash out of 5 Star Media, that was the plaintiff's company, and paid for all these other interrelated companies. And that's important, Your Honor, because when we look for the QuickBooks records that we're going to talk about in a moment, we believe, and there's evidence already that we've been able to establish, that part of the problem is Mr. Holmes and Mr. Harrison were moving money in and out of these different business lines so that they could make them look more profitable, not show the cash shortages. And so those are the records that we're looking for to get to our experts who can conduct a financial accounting or forensic accounting to see really what was happening in the company that was being hidden from our clients. January, this is only a few months before we close on the transaction. Mr. Holmes is asking his CFO, how did things become so much worse than this time last year? And Mr. Harrison is talking about how it's because there's a lot of reasons, but the holidays and mail has killed them, and given the level of receivables that they're facing. And again, they're talking about the need to take out shark loans to just cover these expenses. This next set of emails, Your Honor, is just one example where we have the plaintiffs looking at, if you see on the bottom of this top screenshot, 5 Star Media's balance sheet. And they're talking internally about how they need to take some AR down and move some AR up to reflect a bit more cash. That is, they are actually manipulating the financial records so it looks like there's more cash in the company than there actually is. Now, I know Ms. Pettit has made the argument that this has to do with some other transaction, that they were changing these records so they could get a lease on another company or a lease on a restaurant. But Your Honor, what I will tell you is, I don't have them in here, but we've discovered just in the last couple of weeks, emails to that same effect where these two individuals were making changes to the financial documents to show a $3.5 million EBITDA in revenue, which was the target they had to hit in order for our clients to close on the transaction. There's a whole host of emails where other investors who are owed money are asking to get paid, and Mr. Holmes is telling him, I don't have cash to pay you right now. Just wait until this deal closes with FSG and I'll be able to get money. So there are many, many areas where this narrative about this was Mr. Holmes' life work and our clients have run it into the ground. The documents are showing otherwise, Your Honor. So here's what we've asked for. We want the native QuickBook files so that way we can go back and do an audit trail of really what money.
So let me ask this, because I'm not exactly sure I'm following what you're talking about. So what are non-working QuickBook backup files? I'm not sure what that means.
So this is really just a history of why the QuickBooks files has become an important part. So the QuickBooks files belong to our clients. Under the APA, we own them. We have been trying to get them from the plaintiffs since during the due diligence period. During the due diligence period, the plaintiffs provided us QuickBook files that didn't work. The data couldn't be accessed, no information could get out of it. Since that time, we have over and over again been asking for these QuickBook files because that's the only way one, they belong to our client. We bought them. We bought the books and records. But two, now that we're in litigation and we have these concerns that the plaintiffs had manipulated financial records, the only way to determine if that's true or not true is to look at QuickBook files, because Excel spreadsheets can be manipulated. You can change the amounts in them. We have evidence that Ms. Pettit's clients did do that. But the QuickBook files have audit trails. So it's much harder to have something that's been manipulated, and it's a much more reliable source for experts to rely on. So this part right here on this slide is really just a history of all the times we've been asking for the information, and the plaintiffs were restricting us to get access for these documents that our client owned. And so, as I mentioned, one, these documents, the QuickBook files, our client purchased them, and under the asset purchase agreement in Section M, it states, very specifically that we've purchased all the books and records, including the books of accounts, ledgers, general, financial, and accounting records. We've purchased those, but they've still never turned them over to us. Now, why is that? If you look at the internal emails between Mr. Harrison and Mr. Holm, they don't want our clients to get these documents. Mr. Harrison wrote to Mr. Holm that he removed the access from anyone from Global to the QuickBooks files for media. And then they go through why they did that. And sorry, but at the bottom here, you see, look, QuickBooks goes back to 2013. So anything where money was transferred to any other entity is recorded in media books. That's our concern. That's what we've alleged, that they were moving money in and out of different entities to make the companies look more valuable than they were. That's exactly why we need these documents. And Mr. Holm responds back, Dirk and Ed, that's FSG's CFO and CEO, should never see this stuff. This is what they're saying internally. So not only do the records and property belong to us, these QuickBook records, but as we've talked about, those would be the best way for us to look at and compare to the information that was provided to our clients pre-transaction and see if that information was false, as we believe it was, and compare it to the different true-ups and audits that were done along the way. And as I explained,
is there a protective order for all of these records? Have you guys already entered a protective order?
Yes, we have an agreed protective order that Your Honor has already entered.
I thought so, but I wasn't sure. So,
and
all right, go ahead.
So we provided you the declaration from Gary Durham. He's our expert in this case, which at the end of this hearing, I want to raise an issue that has recently come up, but where he explained through his testimony why he needs the native QuickBook files and the native Microsoft Access files. I'm going to skip over this and come back, but here's the new claim that we heard for the first time this last week from Ms. Pettit, and that is the QuickBook files have been deleted. And of course, that is very concerning for a number of reasons. We have been asking for these documents that belong and files that belong to our clients since during the transaction. The litigation in this case started in November 2019. Obviously, Your Honor, if these records were deleted since the time that the parties have been in litigation, that is a really big problem. But we know from our understanding of how the plaintiffs' operating systems worked, that they were continually backing up all their accounting computers through a number of different ways. And we know that they were backing up the QuickBooks through.
Ms. Shigaris, I just have a limited amount of time today, so let me hear from Ms. Pettit about her response to this. I get the issue.
Okay, thank you, Your Honor.
Thank you, Your Honor. I'm not even exactly sure where to start because there's such disagreements on this. I'd like to at least first address the issue on the email accounts. Ms. Shigaris said multiple times that her client has purchased the email accounts. And I think that's part of
purchase the email or the financial records? The
email. Well, she mentions the email accounts, which are relevant for a number of these things. And just to be clear, that is a highly disputed issue. We do not in any way concede that they own the email accounts of my client.
Let's just focus on the native QuickBook files. What is
Sure.
the issue with that?
Well, the issue is Ms. Shigaris just said that I represented to her that they were deleted. That's completely false. I have an email that I sent to Ms. Shigaris on this issue yesterday at 2:48 p.m. Where I said 5 Points Holdings does not have access to the historical QuickBooks anymore because 5-Star Global stopped paying for it and did not forward payment information. So to state that in any way, either my client or I have ever even in any way said they were deleted is inaccurate. What we've said is there is no access.
No access. I'm not sure why wouldn't there be access again?
Sure. So, Your Honor, 5 Points Holdings had a version of QuickBooks. There's a number of different types of QuickBooks versions you can have. You can have versions that are local to your computer. Like I could open my computer and have my QuickBooks. Mm-hmm. There are also ones that are web-based in the cloud where I could open it, you could open it, Ms. Shigaris could open it. That's the type of QuickBook account.
And that has a monthly service fee or something like that.
And so when the assets were purchased by Ms. Shigaris's client, the invoice and bills were not paid for that, nor were they forwarded to my client. And so access was shut off. I've never said anything was deleted. I've told Ms. Shigaris specifically that we have all of the Excel backup that my client had taken on their own before this access was turned off. And I've told Ms. Shigaris that we'll provide that to her in Excel, which is what we have. So nothing's been deleted. I've never said that. That's not accurate. I don't know what QuickBooks does.
So let me ask this, and I just, this is the first time I've actually heard that that's how QuickBooks, that there's a web-based QuickBooks. And so that, I'm not saying you're wrong. I just didn't know that. So Ms. Shigaris, were you aware of that?
I was aware of the difference. I was informed of something different from my clients, that they actually had the version that was hosted on their own servers and continued to be backed up through this program called Right Networks. So what Ms. Pettit is saying now is just different than my understanding, that it was actually backed up and locally stored.
So whose servers, the servers that you're talking about, who has access to the servers?
The plaintiffs, Your Honor, and if I just might interject, we found emails between authored by Mr. Harrison, the CFO for the plaintiff, that indicated that the QuickBooks records are being backed up, as Ms. Shigaris said, on something called Rights Network Server, and that all of the accounting PCs or actual computers containing the QuickBooks information are being backed up using something separate called Carbonite. We also know that once the asset purchase agreement closed, Mr. Harrison set up a brand new QuickBooks for 5-Star Global and had a new starting point of May 21, 2018 forward. So all of the historical information that we're asking for through QuickBooks, we've never received. So whether or not 5-Star paid for ongoing QuickBooks access is irrelevant, because that's not the information we're looking for through the motion to compel. We're looking for information that predated the asset purchase agreement itself. We've never had access to that information.
So has anyone talked about doing a forensic examination of these? Forensic examination of these computers, or is that something you guys have already worked out?
Well, we have discussed it on our end, Your Honor. We believe under what we would need to show to the court is that would be the only way we could get it, or, there's a heightened standard for getting. So what we're trying to do is get it first through discovery. If we can't do that, then of course we would need a forensic.
Your Honor, I will repeat what I have told Ms. Shigaris already, which is the Excel backup that we have to all of the QuickBooks files, I am happy to give to her. It's a backup that our clients created. Ms. Shigaris and I are in dispute over the dates, how far back that should go, but I've already told Ms. Shigaris that to the extent that we have the backup for that QuickBook, we're not hiding anything, and we're happy to give that to her. And I've said the date is 2015, and we're happy to provide that. And so it's not as if we're saying that we're not going to give it. QuickBooks, as Your Honor, I'm sure is aware, is transactions are manually entered in there. So whether that's in Excel and pulled from Excel or vice versa, the data is the data. We have.
And she's saying that anytime that's done, it's tracked within the program, and that's not done in Excel. Is that my understanding?
Yes, Your Honor.
That's correct.
But that's why you want the QuickBooks. So,
Yes, Your Honor.
so what, if Ms. Lopez is right, then what is the issue with just getting the QuickBooks off of this Canaanite or whatever you said it was, or Carbonite?
Well, first of all, Carbonite is not, I don't know if Ms. Lopez or Ms. Shigaris has any experience with Carbonite. I've used it extensively, and I don't think it's probably what they're thinking, but I don't know if these files were backed up to Carbonite. I can find out if that's the case. I just don't know one way or the other. If they were backed up to Carbonite, well, that changes things. But my understanding is these were never hosted locally. They were stored on a cloud. When the bill wasn't paid, that access was turned off. So if they're on Carbonite and it's the same Excel files that we have, I'm fine producing that. My client has assured me that we simply don't have access because it was stored on the cloud, and that service wasn't paid.
And just to be clear, Your Honor, Mr. Harrison wrote in emails specifically asked about how the QuickBooks and other financial information was backed up prior to the asset purchase agreement closing. And he said that they were backed up in two ways. First is through Carbonite, and the second is, as Mr. Garris indicated, through something called Rights Network Server. All of this is backed up. We also have found emails in 2018 between Mr. Holm and Mr. Harrison, where they're getting notifications for their QuickBooks that their renewal notice is coming. And Mr. Holm specifically told Mr. Harris to renew QuickBooks and to pay for the renewal. So again, irrespective of what our clients did after the asset purchase agreement closed, we have all that financial information. We need the historical period information from 2013 through May 18, 2018. And we know they have it. They've told us they've had it. They told us it's backed up in two different ways. There's emails in 2018 saying they
okay, so again, I have a limited amount of time here. So I'm going to go ahead and order that to be produced, the native. I think there's a dispute whether it should be 2013 or 2015. Is that right?
Yes, that's the.
I need a little bit of clarity. I'm not sure what you're talking about, the native. If it doesn't exist, then it doesn't.
If it exists, it needs to be produced. If it doesn't exist, then
okay.
We may.
So that I'm clear, you're talking about the native QuickBook file, to the extent it exists, needs to be produced.
Right, and if there's not, if your client claims it doesn't exist, then there may need to be, I'm not ruling this today, but there may need to be a forensic examination of those computers to see if they do exist, because it does sound like there's kind of a difference of opinion about what exactly how this works. So so those will need to be produced. Now the issue is what, 2013 versus 2015, is that right?
Yes, Your Honor. So if I may address that, I know Ms. Shigaris has talked about that already, but you have to understand a little bit that we are fighting on our end with both hands behind our back, because they have everything from our data room that was produced to them during the due diligence period. And not only that, but as I've raised multiple times over and over, they locked my clients out of their email accounts. And this entire time, as you can see from their very detailed presentation, they have access to everything that we have not had access to, including, I'll say it again, I've said it 10 times, including all of my privileged emails from apparently 13 years back, while I've 12 or 13 years back while I've represented this company. I've asked multiple times for that issue to be addressed. And as far as I know, they still have access to all of my privileged emails with this particular
But that's not going to be in the QuickBook files, right?
No, but they have all of the emails, Your Honor. That's been our problem from day one. We dispute hotly that they own these email accounts. We say they don't. They say they do. They're going through the emails, including mine, presumably are mixed in there. In regard to the years, Your Honor, they're now asking for more by way of data that they even had when they purchased these assets from my client. There was a data room that was extensive. It's a common theme for these types of parties to have a data room whereby the entity that's having assets purchased provides extensive financial information. They have that information. They've had it since the due diligence period, and now they're wanting to do additional due diligence than they even had the ability to do when they purchased these assets. Everything in this case, as far as what transpired during the due diligence period, and I'm trying to be brief, is that Whitley Penn, a third-party auditor, went in and did an audit. So all of these books, Your Honor, all of these records have been audited and signed off on by a third-party auditor. The third-party audit, which they presumably relied on, looks at documents back to 2015. So I've told Ms. Shigaris, look, we're happy to give you everything back to what the auditor looked at when they were certifying these books and certifying the records. And I stand by that. We're happy to provide everything that we have that's responsive to their request back to 2015.
All right, so we're going to order it back to 2015 then. That sounds, if that's what the audit period was. So
Well, Your Honor, can I just respond on that briefly? That's not correct.
Ms. Shigaris, I'm going to run out of time. So if you want me to be able to rule on things, you got to get to them because I'm going to
Well,
run out
this
of time.
is this is the second most important. Let me just be brief. What she just said, there was an audit that was limited to that. But the financial information that was provided to our client was not 2015 to 2018. It was provided from 2013 to 2018. That's what we relied on. And importantly, Your Honor, we've been sued by Mr. Reamer's client for allegedly fraudulent financials from 2013 to 2018. And those are the financials that Mr. Holm prepared, provided to us, and we passed on to Mr. Knoll. So we've
Is that correct, Mr. Reamer?
Can you say that one more time, Ms. Shigaris?
Yes, that your client's claim on the fraudulent financials is for documents related to 2013 through 2018.
As I sit here right now, I'm not sure that it goes back that far, Your Honor. I would have to double check. I take Ms. Shigaris at her word. That seems. I mean, my deal closed, I think, January 2020.
So this is what I'm going to do. I'm going to order it for whatever period that Mr. Reamer is suing for. If it's 2015 to 2018, it'll be 2015 to 2018. If it's 2013 to 2018, it'll be 2013 to 2018.
Thank you, Your Honor.
Whatever Mr. Reamer is suing for.
Your Honor, if I may quickly make one point. My client provided financial data back all the way, in certain cases, to 2003. So I'm not disputing with Ms. Shigaris that they certainly have documents in their possession, but they couldn't have provided anything to Mr. Reamer that my client had not provided to them. So I just want to make sure we're clear on that.
Ms. Shigaris, did you want me to, you're going to run out of time. So
I know. So, okay, there's the next issue. I'm trying to be brief on this, Your Honor. What we've asked for is Mr. Holmes' tax returns, only those portions that show amounts that he received and reported from FSG. And the reason this is important, Your Honor, is there's a dispute as to whether or not during that time period, remember I said he basically just quit but was still getting paid. We believe he was getting paid salary and other fringe benefits from the company that would be reported a certain way. Ms. Pettit's client alleges that that was actually severance, which would get reported a different way. And so we don't need anything that's related to income or expenses or whatever that don't have to do with our company, so they could redact all of that. We just want for 2019 and 2020 his tax returns and just those portions that show income or expenses.
The case law is pretty clear that tax returns are kind of the method of last resort. Don't you already have audited financials and all this?
May I respond, Your Honor? They actually have something greater than that.
Okay.
If I may respond briefly. So what they're talking about is whether or not this income, if Mr. Holmes treated it as salary or severance. I sent Ms. Shigaris yesterday an IRS circular that shows that on a tax return, they're reported the exact same way. So if you look at Mr. Holmes' tax return, you will not be able to tell if he reported that income as salary or severance because the company sent a W-2. W-2 income is W-2 income is W-2 income. I told Mr. Garris, look, if you have anything else that will show me that it would be reported differently on his tax return if it was severance versus salary, show me and I'll take a look at it. And so far I haven't received anything. So they have his W-2. I told her, send us an RFA that he reported it as income and we will say yes. And I'll represent to the court that he treated it as income. Absolutely, because that's what the IRS tells you to do. It was treated as income. They don't need to see his tax return to confirm that. I'll admit it on the record. My client will too.
Yeah, it's not that simple. I mean, if he received other employee benefits after April 2019, and he did not report those as taxable income because he had been terminated under his logic, that shows that he didn't think he was terminated either. And so I agree, Your Honor, tax returns are a high burden, but that's why we're saying they could redact everything other than those entries for his income from our company.
I'm going to deny the motion to compel on this. What's your next one?
Okay. The next one, and I would think we could still work this out, but two interrogatories, and I haven't bracketed 21 and 22 because that's how Ms. Pettit renumbered them. In this, there were some shared services agreements where her clients could use FSG employees and equipment for non-FSG business, but that they would be, have to pay to the company for that use. There's some dispute as to whether or not that's all been paid or not been paid. Ms. Pettit has stated that they don't have access to the information to answer the request as written. So what our proposal was, if they could just provide information or documents that are sufficient to show the payments that they claim that they've made for these, so we can determine what's the outstanding amount that's still in dispute. And that's what we've asked for.
Response?
Yeah, I could go on and on about this. It's probably, I don't want to waste your honor's time. We'll, to the extent that we have evidence that these amounts were paid, we will produce those. So.
Perfect. Last one.
That's the last one. So I submitted a proposed order, but I think some of the things have changed. So I'll work on one and send it to Ms. Pettit to approve by form, and then we'll get it over to your honor.
Perfect, guys. Go ahead and make sure that you e-file that new order as well as email it to Rhonda, okay?
We will. Thank you so much.
You guys have a great weekend and be safe, okay?
All right.
You too, Your Honor. Have a good day.
Thank you. Bye-bye.